Thank you so much, Alicia. My name is Elaina Roberts, and I am the Legal Director of the Stalking Resource Center. I want to first say thank you to NCJ-FCJ for hosting this webinar series for us. This is part 2 of the 2-part webinar series that we had started 2 weeks ago. And today we'll be focusing on the use of technology that's being used to track and monitor and surveil victims, and then also provide some evidentiary considerations. Before I introduce today's speakers, I do just want to give a shout out to our funder. We are funded by the Department of Justice's Office on Violence Against Women, and for that reason we are a training and technical assistance provider on the crime of stalking. We're the only national provider that focuses specifically on the crime of stalking. And so if you are working with a stalking victim, if you're investigating a stalking case, if you're prosecuting, or whatever way you are in any capacity working in the stalking area and you have questions, we are your go-to people. And if we don't have the answers for you, we certainly can reach out to a number of our consultants who work in the field currently and get that answer for you. So we provide in-person trainings and that technical assistance. Our information is at the end of this PowerPoint, so please don't hesitate to reach out to us. And you can also reach us on our website, and we have lots of resources there for you to check out. So please do so. Without wasting too much time, I do want to introduce today's speakers. The SRC is so happy and pleased to have Judge Elizabeth Berns back with us for part 2 of this webinar series. Judge Berns is a judge with the King County Superior Court in Seattle, Washington, and that is a court of general jurisdiction, which means that they do rotations. And so Judge Berns has served in both the civil, the family, the criminal, and even the juvenile departments of that system. And so welcome, Judge Berns. We are happy to have you back with us today. We also have Ian Harris. He is the Technology Safety Legal Manager with the Safety Net Project, which is a program of the National Network to End Domestic Violence. And he is here to speak to us about all the different technologies that are being used to track and monitor and surveil victims. So we are very happy to have both of them, and I will go ahead and turn it over to you, Ian.
Thanks, Elaina. Really happy to be here with all of you today. So as Elaina said, I'm Ian Harris, and I work at the Safety Net Project of the National Network to End Domestic Violence. We do a variety of things, but basically what we're looking at is the intersection of technology and domestic violence. I in particular am doing a lot of work around issues surrounding evidentiary and other legal specific issues where technology and domestic violence intersect. My background is I was directing a legal services project in New York City before moving to the National Network a couple of months ago. I'm really happy to be here with all of you and really happy to share some of the information. So just a couple of really helpful quick tips to begin with. Obviously this is a national training, so I'm going to do my best, and I think all three of us are going to do our best to stay away from specific types of legal doctrine because we don't want to focus on a particular state's laws. We want to make it as applicable as possible. I want you all to know that we're going to be using a little bit their vocabulary that will be used in different ways. We'll talk about things like intimate partner violence and domestic violence. Know that those are kind of two different ways to say pretty similar behaviors. We're going to talk about protection orders, orders of protection, restraining orders. There's a variety of different ways that different jurisdictions talk about that, but just know that what we're referring to there is the process of a legal restriction on somebody's ability to do something. We're going to talk a lot today about technology and evidence. Now, obviously, there are free speech implications that come up when discussing things that could easily be determined to be speech-related. The reality is that in many cases, we're talking about situations where there are orders of protection, and there's lots of good legal precedent to demonstrate that it's possible to put restrictions on free speech when there are order of protections, but just know that there's that kind of issues in the background. That might be something that we have to come back for a later date, but we're not going to get too deep into that issue just because we want to make sure that the other content is there. And just a really quick piece, I know that people are coming from different types of courts, criminal, civil, a variety of different places. We're going to try to make it as applicable as possible, but I do want you to know that we have a judge who's done a variety of different types of cases. I'm a civil attorney. Elaina has a criminal justice background as a prosecutor, so we have a couple of different perspectives to share. We would love to hear your questions throughout, and if there are specific things that we can either deal with as you're chatting in the chat box, we'll deal with that. We also may push some of them more towards the end, but we're going to try our best to get to as many questions as possible, but we would love to hear from you as it progresses. You don't have to wait until the end. So we're going to try to talk about 45 minutes focusing on tech abuse and some of the evidentiary issues that come up. Of course, we have a short period of time, so we can't deal with everything, but we're going to try to focus on the most common issues that you all are likely to see. And then Judge Berns is going to help to think a little bit about how to bring this information home, and all three of us will hopefully jump in as questions arise. Here's what we're hoping you're getting out of today. We want you to learn more about common technologies that are used in the context of intimate partner violence cases, particularly as it relates to stalking. We want you all to know a little bit about the evidence that correlates with this types of common technological tech misuse, a little bit about the format of that evidence and about the admission of that evidence. And then I just want you all to know, we're not going to get too deep into this, but I have a couple of slides in the resources section that actually list out a couple of real-life examples that I've used in New York, basically language that we've integrated into orders of protection that include tech-specific language, which we always suggest as a good practice to look at what technologies are being misused and to think about how to integrate it into orders of protection specifically. So just know that that is there, and we'd love for you all to look at it and see if that's useful in your jurisdiction. Great. So why does this tech abuse matter for your court? I'd love to hand it over to Judge Berns to give some initial thoughts.
Thank you, Ian, and good morning, everyone, for those of you on the West Coast, and good afternoon for those of you a little bit farther east. You know, as we become more familiar with the nuances of the conduct involved in harm inflicted by stalking, so too must we become more familiar with the nuances of the tactics and the tools that are being used. The advancements in technology pose very unique challenges to enhancing safety, and that's clearly something that we're very concerned about and need to stay proactive around. I think all of you will agree that our courts and judges have a responsibility to become aware of and educated about the conduct that's occurring in our community. And very generally, this shapes our laws, it shapes our procedures, our court rules in each of our jurisdictions, and very practically speaking, it has an impact on our court forms. The definition of community, however, is expanding, and it's including cyberspace as a new vector of activity. And consequently, I believe that we have a corresponding responsibility to be aware of and educated about tech abuse and cyber harassment and how that plays out in particular with stalking. It's also imperative that we understand the pervasiveness of social networking and the changing dynamics of intimate relationships because of technology. That's particularly important that we have a working knowledge of technology and the tactics in light of the reality that I'm sure many of us can appreciate, that there are an increasing number of self-represented litigants coming into our courts, and we frequently find ourselves in a position, especially on the bench, where that knowledge is essential. So I'm very, very excited to learn as I listen to Ian and Elaina, and what you're about to hear and the information you're about to receive is going to start you down that path of education and awareness.
Great. Thank you so much. You know, Judge Berns brings up a really important point, which is that we know that technology is just a more integral part of most of our lives. But it's not just about the fact that it's pervasive and most people use their smartphones for almost all things. It's that it's actually really important for people. And the word that Judge Berns just used, community, is really important to note there. I have had so many clients with whom they've experienced tremendous amounts of isolation as a result of the violence that they've experienced. And technology has really served as a community building mechanism, an essential community building mechanism for them. And that's particularly true for individuals, for instance, LGBTQ youth who may come from places where there's very few opportunities to be true and full authentic selves, and online can be a really important piece of that. And so I just want to note how, not only is it something that we're definitely going to just continue to deal with more, but it's really tremendously important to people. But the other thing as to why I think it's important for you all as judges to know about this is I actually find that tech is changing domestic violence. It's changing stalking in some ways, in the way that the court can actually respond, because it's creating evidence where it didn't exist before. And I'll give you a really good example. So in New York, unfortunately, our civil order protection process can often take somewhere in the range of 8 months to a year to complete, which is a tremendously long period of time. And I know that there's got to be some judges that are listening right now in other jurisdictions who can't believe what I just said, but it really does take that long. I had a case a couple of years ago, and the other side was, so there was 2 attorneys on the case. I went in on the first day. We'd never, it was the first time anyone had appeared. And I basically said to the other attorney, listen, my client just wants to be done with this situation. She wants an order of protection. She wants to be protected, but, there's no kids, there's no assets. This can be a clean break. And the attorney got really, sort of puffed up his chest, and he told me that they were going to take this case to the very end, and they don't care how long it was going to take, that justice would, prevail, and all of these things. Well, the guy that my client had experienced the abuse from, he had actually downloaded an app into her phone that was recording every conversation that they had for about a 6-month period. And so I'm looking at this attorney who's telling me all of the ways that he is going to fight this, tooth and nail to the very end. And I had recordings for about 6 months in which his client had repeatedly told my client that he was going to kill her, how he was going to kill her, where he was going to kill her. So the attorney puffed up his chest. I took out the phone. I put it on the table. I pushed play. And all of a sudden you hear his client's voice saying all of these terrible things. And if I was in front of you, I'd ask, what do you think happened? But we all sort of know what happened is that case that would have taken 8 months to a year took about 2 minutes. And that's what's really great about tech, is that it's giving us evidence that was really hard. And I want to acknowledge how difficult it really is to preside over cases that involve stalking, that involve intimate partner violence. But it gives something for the judiciary to look at and hold as tangible evidence to really come up with better dispositions. Great. So I have been, part of my job is actually building a curriculum with the National Council for Juvenile and Family Court Judges about the issue of technology and intimate partner violence, specifically building a curriculum for judges to make sure that we are getting and responding to all of the issues that are most important for you in your courtroom. So we would love to hear if there are things that you definitely want included in that curriculum. Please include it in the chat, and we will we'll definitely do our best to include it. But what we have found in that process of speaking to judges all over the country is that there is a miraculously low level of comfort by many judges with very sort of normal technological things. Everything from we've heard about judges feeling uncomfortable even typing into a computer rather than writing directly into an order of protection. We've definitely heard a lot of judges giving us feedback that social media, because of concerns about ethical standards, because of concerns about safety of friends and family, that many judges we're talking to will not go anywhere near social media accounts And many, I can't actually tell you how frequently I go into rooms of judges where somebody or multiple people will hold up their flip phone to let me know, that they are still working off of a flip phone that, maybe from 10 years ago. Now, I think there are good reasons why judges don't always necessarily want to be participating in some of these technological things, but it does make it hard when more technologically advanced issues come into your courtroom to know how to effectively deal with that. And that's especially hard in situations where I'm sure many of you are dealing with, where you have pro se litigants who don't have sufficient resources to bring in the type of experts that might really assist you all in making the determinations that are going to potentially save people's lives. So here, what I wanted to just lay out a little bit is that technology is at its base. The things that end up resonating with our society, the things that become very popular, are really just things that are very common tasks that have sort of been brought from a low tech to a higher tech. So Facebook, probably the one that people think about the most. Facebook was basically a thing that was happening on college campuses. It was a printed out book where you had incoming students, some of their interests, a picture about them, a way to know people, right? And so Facebook took that and they put it online and they made connections that way. And then they created this thing called a wall. And on the wall, that's basically just a wall. It's a bulletin board, right? They took a bulletin board that we would see on a college campus and they put it right there onto the screen. And that's what so many technologies are doing. They take things that are very normal and they make them easier to use. They make them more accessible. They make them faster, louder, and sort of more easily replicated. Now, that can be really great because, for instance, I don't actually know, as much as I cry about the number of emails that I'm getting every single day, it's hard to imagine sometimes how work was able to move forward without email communication because it's just so rapid paced. There's so much communication going back and forth. But the truth is that technology has that benefit, right? It makes things go easier, faster, but that's also its downfall, right? So when somebody says a harassing thing or shows up outside of someone's home, that's terrifying and that can be really impactful. But if somebody can say a harassing thing and send it out to 1,000 people with one click of a button, that's a whole nother kind of bag of tricks. And if somebody can, instead of just showing up outside in the bushes, is able to actually track where you're going all of the time, is able to see where a person is at all of the time, this has some serious implications for safety, for people's emotional, psychological well-being. It has some pretty serious implications that are obviously important to you all, which is why you're here. So here, there are a variety of common technologies that we're seeing: phones, emails, GPS systems, computers, assistive technologies. All of these things are starting to come into the courtroom. What we're finding is that when we did a large nationwide survey, about 97% of the domestic violence programs that we've been talking to reported that abusive parties were using technology to stalk, harass, and control. Now, that 97% tells me a lot of things. One, it tells me that 3% of the programs we talk to are total liars, because I don't imagine for 1 second that they're not also dealing with that issue. Because it's really, in the last 5 years, there's been so few cases that I've had that did not have a tech component to them. But it also tells me that really this is, no matter where you're from, whether it's rural, whether it's seriously urban, we're talking about lots of use throughout the country and important for really all strata within society. I want to take a quick second just to reflect on a situation that I've heard. So, it can be overwhelming when you get a client who's experiencing serious technological stalking and abusive behavior. It can be very hard to safety plan. It can be very hard to think through how to really protect somebody in that situation. And I'll be honest, part of me sometimes wants to say, can't we just turn off the tech? But I do want to tell you why that many times is not going to be a good option. I had a case a couple of years ago. It was going on for about a year and a half. We'd been litigating it. There was a criminal component. There was a family court component, both custody, visitation, and civil order of protection. The other side continuously violated the order of protection by sending text messages and things to that effect, to the point that my client repeatedly was going to the police precinct, and the police precinct actually was refusing to even take reports anymore. They were just sick of hearing about it. The prosecutor on that case, who was actually a very good person and had really good intentions, had been really pushing my client very hard to get rid of, to basically change her number and get rid of her phone, so that in hopes that this person would stop violating the order of protection. I spoke really at depth with that client about the pros and the cons of that decision, and ultimately we decided that she was going to keep the phone. We went to court one day, and the night before court, the guy sent a text message. It was a picture, and in the picture was a hand with a little tattoo that was his tattoo, and the hand was holding a gun. We told the court about it. He wasn't in court that day. The court said it's very important that you go and arrest this person because it's dangerous. Fearing that that wouldn't actually happen, I got my client out of the house and into a safe space for the next day, because we were actually supposed to go back to court the following day. I received a call very early in the morning, and my client was crying hysterically. It turns out that that guy had gone to my client's house and asked for her. She was a college student. He went to her home about 10 minutes after she usually arrived home. She had a child and was a college student, so she had a very strict schedule. She wasn't there because we received a text message. We received a picture that let us know to get her out of the house that day. It was the only reason that she was not there was because we received that text message. We got her out of the house. He arrived. He asked for her. When she wasn't there, he pulled out the gun and he shot himself in the head and killed himself in front of her entire family. It was a really terrible thing that happened, and he told multiple people on the way over that he planned to kill himself and to kill her. He went with a full clip. The only reason that she's alive today is because we didn't turn off the technology. It gave us the information that we needed to keep her safe. And so I always remember that when I'm thinking, when I get the call where I'm just like, why can't you please just disconnect? Because sometimes disconnecting is tremendously dangerous for people. And so just want us all to keep that in mind when we get that instinct.
Hey, Ian, this is Elaina.
Yeah, sure.
We do have two questions that I think are worth just taking a moment to address. The first question, they're related. In the other example that you gave on the protection order case, I think there's a little confusion as to whether the victim recorded the conversations that she was having with the offender or whether those were voicemails that were left. And then I guess in response to that, could you address wiretapping laws and first party or one party, two party consent states? Because in a lot of states, if it was a recording of the conversation, we know that that can't be used as evidence.
Sure. So in that particular scenario, what happened was we actually saw the guy had downloaded an app, and the app was recording both sides of the conversation every time they spoke. So it wasn't voicemails, it was actual recordings based upon he had downloaded something on the phone that was recording those conversations. It was not voicemails. In terms of wiretapping laws, I mean, that is complicated. The vast majority of the states, I believe at this point, have one-party consent laws. So, most states, if one party says it's, the person who's actually recording it is okay with it, that usually is okay. There are definitely some states that have two-party consent laws in which both parties have to consent. That issue definitely comes up a lot in the context of custody litigation, but there are many, many situations in which it's totally going to be legal for somebody to record a conversation without the other person's knowledge, because many states have one-party consent laws. Now, the basis of those laws is really to make sure that reporters and the media are able to record things is kind of where that comes from, but it has applicability in other situations. Now, in cases, I've had a number of situations where in New York we have a one-party consent law, but I was able to get recordings kicked out of court in which the other party recorded some sort of conversation happening between my client and the child, for instance. So a situation in which they were not necessarily a party, the recorder was not a party to the conversation, then that usually is going to bring up issues of whether or not that can be admitted into court as evidence. But like I said, if a person is a part of the conversation, many states have one-party consent laws, and so they would still be admissible in evidence. I hope that responds to the question. Elaina, does that feel like that gets to, I actually haven't seen the question, so does that feel like we got to that question?
Yeah, absolutely. I think everyone's weighing in now. It really does vary from state to state. It's just important to know what your state requires. So yeah, thank you.
Great. Perfect. So moving forward a little bit, we're not going to get too deep into sort of the theory behind many types of electronic evidence because that's a course unto itself. But just suffice to say that most tech evidence is what's called electronically stored information, and it's really information that's best collected and maintained in sort of a digital format. And the reason for that is that it's hard to determine what an original is, right? So if I send an email, what's the original email? Is it the one that I typed onto my computer? Is it the one that's living in the cloud somewhere? Is it the one that is landing in someone else's email inbox? There's so many different things. But the reason that electronically stored information is generally best living online is because you have both what you see as well as what's called metadata, which is all the stuff that lives behind the thing that you see. The truth at this point across the country, and when we're talking to judges, this has definitely been my experience and many attorneys' experience, but I've also heard from many judges across the country that the way that most electronically stored information, the way that most digital evidence is coming in is generally as hard copies, so printouts of those type of electronically stored information. And so I think that's generally true. Now I think that the trend is probably going to veer in a different way in the near future, but many courthouses don't actually have sufficient technological abilities to deal with other types of evidentiary things. So for the most part, what we're talking about here is hard copies of electronically stored information.
And Ian, can I just jump in? This is Judge Berns.
Sure.
What that will bring up for most of us having to evaluate that document that comes in, that printout, is something I know Ian will talk about in a few minutes. One is ensuring that you have the context of the conversation represented in that document, because as many of you may have seen before with a printout of texting, for example, or emailing, it's very easy to cut and paste on that and clip out the conversation or the few words prior to the ones that have been highlighted. So the context is really essential in doing that and understanding kind of how you evaluate the information that you're receiving in writing.
Yeah, and hearing from judges a lot, I think I've spoken to a lot of judges who are really concerned about it, although I'm hearing mixed things. Many judges are like, I love this text message evidence because, it takes it a little bit outside of just one party saying one thing and the other party saying something else. We have something to work off of. But of course, there's always concerns that we want to make sure that we're getting the evidence that is as airtight as possible. Most litigants that come to me, the things that they're bringing is they oftentimes are not really great at always thinking about maintaining an entire conversation. They sort of see a text message that really bothers them, and so that's the one that they want to make sure that the court sees. So, part of the attorney's job is making sure that that information, the entire conversation, is getting to the judge. But the only way that I've been able to effectively do that is to really build in as processes from the very beginning, letting it be very clear to litigants that they need to maintain that stuff, because many litigants, especially pro se litigants, actually have phone services that are not maintaining that information, or it's a month-to-month or some other type of lower cost phone service that is not maintaining that information for them. And so it's really important to get to them early on to make sure that they're retaining it, because a lot of times I'm hearing from clients that don't actually have bad intentions, they just don't know that they have to maintain it. And so one thing to just consider, and I hope that all courts will consider this, is really the importance of having information available when people come to file, particularly for pro se litigants, that says a little bit about how to maintain a little bit of information, and some about the evidentiary process, because so many pro se litigants just don't know about it. And so there's a lot of education that has to end up having to take place there. So for the sake of time, what I want to do today is, the truth about the way the technology is moving is that we're really moving away from multiple different technologies and instead more towards an integration of technologies into one singular thing. So mobile technology, our smartphones, are really becoming the way that so many forms of tech are starting to intersect, right? So they're a phone, they're surveillance, they're a computer, they're internet, they're all of that stuff together. But I'm going to talk about them in broken up ways. I'm going to talk about telephone, I'm going to talk about surveillance, and I'm going to talk about computer and internet technology. One, in different ways. One, because I think that the information is, the evidence may look slightly different. And two, I just think it's a little bit easier to wrap our brains around. So know that many of these things actually intersect in the context of a smartphone, but they also exist by themselves as well. So we're going to talk about them in that way. So we're seeing, for sure, what I'm hearing from judges around the country, and definitely my experience as well, is that the two major issues that judges are seeing most are text messaging and social media posts. Those are the tech issues that most judges are dealing with most frequently, and that's been supported by some of the research that we've done. The ways that we're seeing telephones being used abusively are the constant text messages, the constant chat and instant messaging. The reason that I've highlighted those is I want you all to know that the interesting thing about how technology has kind of moved forward is that you can have two separate things with two separate types of evidence that are going to the same place on the phone. So for instance, on my phone, I have an iPhone, and on that phone I receive text messages. And now, we know what a text message is, right? It's somebody is sending usually words, though at this point we have two different types. There's SMS, which is the words, and MMS, which is the multimedia, so videos and pictures and all those sorts of things as well, emojis. It's the sending of that, and it shows up in an app on my phone called Messages. Now, the interesting thing is that on Messages, I get the same place. I click on the same thing with my thumb on my phone to get messages, but those messages can come from multiple different places. So they could be sent as what we'll call a text message, which is something being sent over the phone line. So let's say Verizon. So Verizon, you have your Verizon plan, you send a text message, it goes to Verizon satellites and is shot back down. Now Verizon is going to have some of the records of that. I will tell you that all phone companies at this point delete the actual text of a text message very, very quickly. The longest I've heard is that some of the higher cost ones will sometimes keep the actual text of a text message up to 4 days, but that's the longest. Most of them, especially the lower cost options, are deleting them almost instantaneously and not maintaining that information at all. So that's important to know from an evidentiary level, whether something is a text message or it is an instant message. So an instant message, for instance, on the Apple platform, it's called iMessage. An instant message can be sent, and that will also show up in my Messages app. Now, the difference between these things, really, visually, I'm not going to necessarily be able to tell the difference between them. However, evidentiarily, there's a huge difference. So whereas a text message sent from Verizon is only going to be accessible if I still have the message on the phone, or if I'm able to get to the phone company very, very, very quickly to ask them to maintain that information. Whereas an iMessage sent via the Apple platform, I'm going to have it in a couple of different places. So I might have it on my phone, I might have it on a computer or a tablet that are connected through iCloud, which is the mechanism with which you can basically connect multiple different forms of technology under the same, so that it's almost instantaneously coming up. If I'm getting a message, it will come up on my phone, it will come up on my laptop, it will also come up on my tablet all at the same time. It also might be stuck on the iCloud as well in another space. So there's a couple of places that I might be able to maintain it if it's an instant message, and I might be able to access it, whereas a text message is much more limited. And so there's a variety of times like that with technology where it's really important to know, are we talking, what type of a platform is being used, because the evidence may look very, very differently. And so when a litigant comes in and says that the text message is gone and it's deleted, that really may be true if it is in fact a text message. If it's an instant message that's being sent, that might be a different situation altogether. In addition to the text and the chat, we're also seeing, just the very traditional, the hang-up calls, the constant calling, the voicemail. We're going to talk a little bit about spyware later, but spyware is essentially a platform, a type of software that's going to allow somebody to remotely see what is happening on another device. So if Elaina had put spyware onto my phone when we were in San Francisco last week, she would be able to see all of the things that are happening on my phone, including when I'm typing in my, whatever Google search I'm doing at the time, angry cat faces or whatever it is that I'm doing. She would also be able to see what type of passwords I'm putting in. Basically, anything that's happening on my screen, she would have access to it. We'll talk a little bit more about spyware. Sexting, people always want to talk about sexting. We're not going to get too deep into it, but basically, the sending of nude and semi-nude photos. Sometimes there's text that go along with it, but generally the primary issue is going to be the images. Now, sexting itself is not illegal. It may be illegal if you're talking about minors being depicted, but generally sexting itself is not necessarily illegal. There are a variety of states, I think in the 30s maybe, at this point, who have started to build revenge porn laws. And in those laws, you have legal limitations on whether the ability to sort of coerce and use other people's nude and semi-nude images. But many states at this point don't have any legal prohibitions on the sending of that either. And most people are kind of forced into a situation where they actually have to go through the process of doing copyright claims in order to get access and a little bit of control over their data. But it can be really, really tremendously problematic. All sexting does not necessarily, of course, lead to the issue of non-consensual image disclosures, or which is we oftentimes call revenge porn, but it definitely does happen. Other things that I want you all to know about are spoofing. So spoofing is the ability to basically, so most phones, most devices at this point have something sort of akin to a caller ID, where if somebody is communicating with you, it will show on your caller ID, or it will show in the email who that communication is coming from. Now, spoofing is basically hiding where the call, the email, the text message is coming from, and instead making it appear that it's coming from a different source. Spoofing may be illegal if it's to, if it's for the purposes of fraud, but there's actually some pretty strong limitations on what you can actually do in that situation, and it's a pretty common issue. We are seeing, there used to be a pretty big problem with spoofing through apps that were coming in, through the Apple Store and other other things, but Apple has done a pretty good job on cutting back on that. However, the Android-based devices still have lots of access to spoofing. Apple devices that have been jailbroken, so sort of where you can get things that are not just from the Apple Store, also have access to those things as well. And then there are a variety of online processes where people can do it, and that's both specific to things like spoof card, which really are their purpose in existing is for the process of spoofing. There are also a variety of other things like, let's say, on my phone, for example, I have a Google Voice number. It's a different number than my actual cell phone number, but if somebody calls it, that number will ring on my cell phone. It's free, and it is connected in some ways to me, but in many ways it's not actually connected to my name or anything. I can sort of create a new identity, although I do need to provide access to an email address and those sorts of things, but those can be faked as well. So what I'm seeing more often than not, we used to see a lot of spoof card, a lot of focus on these spoofing specific apps and technologies. More often than not, what I see now is people getting free numbers from things like Google Voice and other free accessible numbers and using those to spoof. So the reason I'm kind of harping on that is I want you all to know that it used to be a situation where we could send out a bunch of subpoenas to these spoofing technologies. Now that's a lot more complicated because we're talking about people who are using Google and other huge companies, and there's serious limitations, particularly in the civil context, as to what information you can get access to, a little bit stronger in the criminal context. Great. So there are, of course, some technologies around that are much, much higher grade. There are things called spy phones. We don't see those very often, so I'm not going to get too much into it, but there are other ways for people to get access to phones as well. Great, we talked about those. Okay, so as I said earlier, chat and instant messaging is something that is very accessible on phones at this point. So what we're noting is that many people are actually communicating via these instant messaging services rather than using their native texting abilities through their phone service because it's cheaper and easier. That's everything from Skype to a variety of different Google products. Yahoo has a messenger system. There are a whole slew of these. There may be ways to get access to that information, but more than as evidence, but more than anything, I just want you all to know that these are some examples of the platforms, and that just because someone says a text message doesn't necessarily mean that what they received was in fact a text message. These are some of them, as I was talking about earlier, go directly to the person's messaging app on their phone. Some of them have their own separate app. So I want to highlight WhatsApp right now. WhatsApp is very, very popular for many places around the world. And anybody who lives out of the country, generally uses it. It's free. It works pretty well. And so that in immigrant communities, if you have large immigrant populations, it's very, very likely that WhatsApp is how people are going to communicate. So just something to kind of keep your eye out for. Judges frequently ask me about the issue of the disappearing message. It is very true that there are some platforms that allow somebody to send photos, that allow people to send videos or other types of text messages, and that those messages, whether it be video or text, will actually sort of disappear. Snapchat is an image-based one that is used pretty regularly. I spoke to a Snapchat person the other day, actually, one of the representatives. It is very hard. There may be some possibilities in getting access to something that's been deleted, but for the most part, once it's gone, it's gone. There are some abilities for if somebody receives something for them to take what's called a screenshot, which is sort of like a picture of the phone to maintain that information, but most of the platforms are going to alert the other person that the image has been taken, and some of them actually have prohibitions on the ability to do it. So if somebody says that the message was there and then all of a sudden it disappeared, just know that they very well could be telling you the truth, because there are a variety of different platforms that allow you to do that. Surveillance issues. So we see, and this is of course a huge issue in the context of stalking, and so we want you all to know about it. We don't see it as much as the other types of abusive behavior, but it definitely happens. When we get the call saying we think that somebody knows exactly where I'm at, we're going to talk to them about a variety of things. I'll tell you, we're always going to talk to them about the lowest tech option. So is there any friends or family members that know about where you were going that might have accidentally shared that information? But we do see GPS systems sometimes being installed in people's cars. Very frequently, we see GPS systems being installed. GPS is basically native to almost all cell phones and smartphones at this point, and so there are a variety of different tech applications where somebody could basically see where another person is at on a map in real time, as without doing too many modifications to the phone. Basically, you can send a request for somebody to allow you to have access to their location. If a person has physical access to the phone, they could very easily download it. Just to give you an example, I spoke to a police officer a couple of years ago, and I was talking about this issue. The police officer was jumping up and down, was really excited, and so I said, "What?" I asked her what she was, so excited about, and she let me know that she was tracking her son, and that she'd been tracking her son for a couple of years. And I asked her, how long it took her to put it onto the phone. She said, he went to the bathroom, and I put it on his phone when he was in the bathroom, and that he's had no idea for a couple of years that he was actually being tracked. So GPS is definitely an issue. The issue of cameras, there was a time in the 90s where everybody was deathly afraid of nannies, and there was all of these nanny cams that were these very large teddy bears with one large eye and really grainy black and white pictures that were taking images of nannies abusing children. The camera technology has changed substantially. Now what we're seeing is very cheap, $10, $20 for a camera, and the camera can be seen remotely, so it sends a signal that can be seen in a computer far away. It doesn't come up in a ton of cases, but it's definitely a possibility. I had a case a couple of months ago in which a person had basically two little USB flash drives, and the USB flash drives had cameras built right into them, and they put them surreptitiously around a home when the other person wasn't there, and was recording actually the shower where their younger daughter was going into the shower. It was not a biological daughter in common. So it definitely does happen. The other thing is social networking. Many social networks at this point ask people to check in and share their information, and so we're seeing more and more cases in which somebody has accidentally shared their information, and that has allowed the stalker to find access to the person. So GPS systems, we talked a little bit about the different places that they can be. Not happening actual physical devices. We don't see those as much anymore because it's so much easier to just upload software. Many, in the context of domestic violence cases where you have people who've shared plans, there are many family locator plans that will allow somebody to see where their family member is at all times. The good news is that we've been able to, us and some others have been able to advocate effectively to get many of these family locator plans to fairly regularly let people know that that information is being shared. It's but we're still talking about maybe once a month for most of the platforms. And the challenges there are that being stalked for a month is a substantial period of time and really frightening for people, of course. Cool. So spyware. We know that spyware is on phones and on computers. Spyware on the phone at this point, as far as we can tell, you actually have to have physical access usually to install the spyware. It's not a situation where you could just send somebody an email, they click a link, but spyware is showing up on phones more often. Here are some of the ways that people can tell. I will tell you, spyware is what's called a ghost file. It is very hard to tell if it's actually on a device like a computer or a phone. Even a professional oftentimes will have a hard time doing that. So some of the things that you might hear in your courtroom in terms of evidence is that their battery was draining very quickly or was getting very warm, that they had huge spikes in their data usage that people can get. I've had clients go to their cell phone services and ask them for records of their data usage, and you'll see these really large data spikes on their bills because the spyware is constantly sending out information. But I will tell you, spyware cases are tremendously difficult because it's hard to see where they came from and oftentimes requires just trashing the device. Okay, so we talked about computers, great. So for the computer piece, all I want you all to know, I'm sure you're seeing a lot of different ways in which computers and social media are being misused. The things that are really constantly happening are the changing of passwords and gaining access to accounts without the person knowing, posting rumors and those sorts of things, impersonating people, doxing, which is the sharing of a ton of information online about a person. What we unfortunately know at this point is that it's very hard in the civil context to get these types of records from the large social media and technological companies. So federal law basically dictates that these companies, for the most part, have to respond to criminal subpoenas, but civil subpoenas, they only will respond if the civil subpoena is domesticated in the place where the company resides. So that's usually in California, which means from New York. I would need to get a judge in New York to sign it. I would then need to send it to California and get the California judge to domesticate it and sign the subpoena as well. It's very hard, it's very expensive, and can be really hard. The great thing for you all to know is that all of the major tech companies, for the most part at this point, social media companies, have ways that people can get a bunch of information about what has happened on their account, what IP addresses have accessed it, and other types of information that might be accessible. We've had some pretty good success with getting that admitted into court. So it is hard to get it from the company, but many of these programs actually have ways that people can get it themselves. Here's just some of the things that have impersonation issues that have come up in recent years, and the issue of increasing number of posting of videos of horrible acts, murders, rapes, definitely stuff. There are more and more videos coming up. Across the country, there's something called data aggregators, and data aggregators are stuff that basically collects all information from social media and collects information from public records and can really help somebody to effectively stalk somebody. So there are a million of them. Spokio is probably the most common one, but just want you all to kind of be aware that information from your courthouses about cases and other information is easily accessible by somebody who intends to stalk, and it's important to think about the pros and cons of certain information getting out because it can really highlight where somebody is at. All right. So learning points. There are so many ways I could talk for days and days about this, and I hope to hear more from questions from you all, but technology can really help to amplify the abuse. It's not necessarily new types of abuse always. It's really taking abuse that you all have seen for a long time and just making it bigger, louder, stronger, and faster. That getting rid of the technology can be extremely dangerous, and it's not oftentimes the answer. That technology, we didn't get to talk about this too much today, but technology actually can be really strategically used to enhance safety. And so, hearing from people about what they need is really important. I've talked to so many clients who had great ways of using tech to keep themselves safe. Tech evidence is definitely admissible. It's not enough to say that something could be modified. It has to be that there's a high likelihood that it has been modified. Tech evidence certainly can be modified, but so can many other types of physical evidence. So we are seeing it being admitted all across the country, and it can be tremendously useful. And we do think that it's actually really necessary in terms of coming up with effective dispositions. I'd like to turn it over to Judge Berns at this point to close us out.
Okay, well, thank you. I've been watching the chat that everybody's been bringing up about recordings, unlawful dissemination, talking a lot about social media, the different applications, and really what that's telling me is that everyone's sort of watching, hearing about this, and I'm curious to know, how much is coming into the courts at this point, and what does that look like? If you can take just a minute, and in fact, not even a minute, but if you could just put out there, what are you seeing? Are you getting social media coming into your court? Are you getting mostly the texting and cell phone related issues into the court? What's happening in your jurisdiction?
And Judge Berns, this is Elaina. I can help monitor this, but I'm sure you can see it as well for when people are starting to type in.
Yeah, that's great. Some people are saying all of those things. I know we've got a lot of people typing in there. And as people are typing, I'll keep an eye on that. But, really the question becomes is how can we bring this information not only to our court, but how can we work with the information in our court? See lots of social media, texting, yep, this sort of thing is happening. And this is such a unique webinar. I feel so privileged to be a part of it, but also I'm just so thrilled that it's coming to all of you because it's really unique in the sense that it's just about technology. Certainly within the stalking context. What you're going to be able to find out there, there's so many wonderful resources that can be brought to us by NCJ, FCJ, NJDIV, where you can get out and take courses on whether it's stalking, domestic violence, within stalking, sexual assault, and within the context of learning about that, you're going to get the technology piece of that. So all of our national trainings that are brought to all and available to all of you are bringing in the technology piece. The other thing that I'd like to share with those of you may or may not know about the National Computer Forensics Institute, and that's based out of Hoover, Alabama, which isn't too far from Birmingham. That is an incredible program. I just attended a course there in June that's just for judges. They do a lot of other training and programs for law enforcement and prosecutors, but there's a judges program that really emphasizes cybercrime and computer forensics. And it talks not only about some of the technology that's out there, but you have an opportunity, you literally take apart a computer so that you understand its contents. You literally use software to do a mirror imaging of someone's cell phone so you can see how that happens. And then there's a lot of discussion about search and seizure related issues on phones for those of you in the criminal sect and dealing with pretrial motions and probable cause and warrants that will pertain to all of that, as well as a huge component on social networking and some of the evidentiary issues, in particular regarding authenticity of evidence. And so I highly recommend that you look into that. It's a fully funded program for judges, which means you don't pay anything out of pocket to attend. You do have to apply, and I'll make sure that I get some contact information over to Alicia and to Elaina for those of you who'd like to follow up on that, but I do recommend it. So it's about getting educated in particular and then coming back to your court and sharing that information with your bench, sharing those materials with your bench. And then it's sort of, you've got to jump in and you're going to make those decisions and you're going to create case law as it happens in your courts. So that's really what I want to push, is just taking the assertive to get educated and to go out there and really tap into the incredible resources that we have available through all these programs. And Elaina, did you want to close out with some last piece of information on our webinar?
No, I do want to say thank you to you, Judge Berns, again for your time. I know you are hearing a docket this morning, and we appreciate you being with us. And also to Ian with the Safety Net Project for being with us as well. I know we are just about out of time. It is 1 o'clock. But Alicia, I don't know if we could just see if there are a couple of questions. We can always follow up via email as well. You can certainly reach out to me via email. And I know, Ian, I believe you will be accessible via email as well.
Yeah, that's right. And I'm putting up, there's my email just in case people want it. And I just clicked through some resources as well. But we'd love to hear any questions that you all have, and we can also take them via email. Happy to talk to you.
Alicia, what do you think? Do we need to start wrapping this up?
We can go ahead. Yeah.
Yeah. So go ahead if people are able to stay.
Okay, let me just review some of these questions.
I just saw what is the best way to collect evidence of text messages. We definitely suggest that people collect it via, as Elaina said above, screenshots. And there are a couple of technologies that are starting to actually be able, you can essentially do like a video as it's slowly scrolling up. But for most people, we use screenshots and try to make sure that clients know about how to do screenshots effectively, and that is including the entire conversation and basically going up, taking a screenshot, pulling it up about 3/4 of the way, taking another screenshot, pulling it up 3/4 of the way, taking another screenshot so that you're getting the entire conversation.
And did you want to, I'm sorry,
go ahead.
Did you want to say something about the warnings regarding blocking a cell phone number? And I think maybe it goes to what you were talking about before in terms of sort of a concurrent safety issue for victims. But did you want to just explain that? I know we had to flow through that slide.
I mean, the problems with blocking numbers is that you have the situation that I referred to earlier where there's a chance that you're going to miss a really essential safety warning sign. Sometimes knowing where the person is at emotionally actually is the safest way to respond to it, and so blocking numbers is not always going to be the best option. There might be some circumstances in which that is good if somebody is safe and physically removed and the person doesn't know where they're at, and there's a variety of different kind of safety planning steps, but blocking numbers generally is not the best way to go about it, really, because it's about the person's misdeeds, not about cutting off technology for the person experiencing the abusive behavior. So we really try to push against that. But the other thing to remember is that it's so easy to get any number of separate free numbers from a phone through the spoofing discussion that we had earlier. Basically, blocking a number becomes really inefficient because you'd actually have to continuously block new and new numbers if a person wants to create a variety of free spoofing numbers.
Thank you, Ian. And I think just based on time, we're going to end with that. I know there have been questions about installing spyware remotely. And I will just say this, again, I'll refer you to the SRC website. It's victimsofcrime.org/SRC. But if you just Google Stalking Resource Center, you will come across our website. And we do have a use of technology to stalk video up on our website. So you can view that. There's also a use of technology to stalk online course. And you can register, and we have to give you permission, but you can register to take that. And that might help answer some of those questions. Again, you can also contact us via email. I certainly would love to follow up, especially on the spyware questions, if you still have them. Please reach out to us. And I just want to thank, again, Alicia and NCJ-FCJ for hosting this. Thank you all so much for being here today. Thank you, Judge Berns and Ian. And we hope to see you all again in the future very soon. Thanks so much, everyone.
Thank you, everyone. I still have a couple of questions coming through, so I'll let people type those out. You will be directed to a brief evaluation afterwards. Let us know how we did. And if you're interested in receiving a certificate of attendance for today's event, you can also request one via the survey link. Thank you all. Have a great day.
Thanks, everybody.